Welcome to Crash Course Injury Law with Joe Ghabour.
Hello and welcome back to Crash Course Injury Law with Joe Ghabour, founder of Joseph M. Ghabour and Associates. Joe is a personal injury attorney licensed in New Jersey, New York, and Florida who helps accident victims and their families navigate medical bills, insurance issues, and the legal process with clarity and confidence. I'm Kevin Rosenquist, and today we're breaking down the timelines that shape an injury case, from how long you have to file to what happens when both drivers share the blame. Joe, good to see you.
Good to see you. How are you?
I'm good. I ran out of breath there in my intro. I need to take a breath every once in a while, I guess, when doing that. So, all right, back to our topic, though. What kinds of time-sensitive steps right after a crash can sort of make or break an injury case later on?
Well, the first few days after a crash are very, very important. Evidence can disappear quickly. Insurance companies can later on ask or question anything that isn't documented properly. So, at the very least, you want to make sure that a police report is filed. You want to take photos and videos of the scene if possible. Obviously, this assumes you're in a safe location. Don't just get out in the middle of the highway and take pictures. That's definitely not safe.
It's not a good idea.
No, definitely not. So, get the safe place, take some photos, some videos of the scene, of the drivers, of the license plates of the cars, etc. That way, you have some evidence as to how the accident happened and how much damage was caused as a result of the accident. Get any information on the driver that you can. Get any information on any witnesses that may have been there, because that will come in handy later on. And of course, if you're injured, definitely seek medical treatment right away. If you're not injured, that's fine. Sometimes the injuries don't really manifest themselves until a few days later. But if you're injured at the scene, definitely get yourself checked out. You don't want to have any underlying issues that are not properly diagnosed, which can, result in more trouble for you. And of course, as a catch-all, preserve anything at all that you can relating to the accident. So try not to skip any of these steps. Try to do what is necessary to make sure that when the time comes and evidence needs to be presented, whether to the insurance company in pretrial settlement negotiations or whether at trial, make sure that everything is documented. Any gaps will be used against you. So the evidence becomes, or the documentation becomes, the backbone of a strong injury claim.
What's the statute of limitations for most personal injury cases in New Jersey, and when does that clock start ticking?
So as with every rule, there are exceptions. And one of those big exceptions is if you're involved in an automobile accident or any type of accident against a governmental entity, whether it's a state or local government in New Jersey. You must file what's called a notice of tort claim within 90 days of the accident occurring. If you don't, you could potentially give up your right to file a lawsuit later on. So, of course, there's an exception to that rule if you are, God forbid, in a hospital and you're in a coma, or you're just out of it for those 90 days or so. There is case law that says you can file a motion in court to ask for permission to file the notice of tort claim out of time. That can only occur, though, within the first year. After that, you cannot, file a motion for such relief. So it's very important to pay attention to, who the defendant is in a matter, and if it is the government of any sort of governmental agency, you must file a notice of tort claim within that 90 days. So that's a little caveat there. The other thing is, if you're suing the Port Authority of New York or New Jersey, for example, you technically do not need to file a notice of tort claim because they're not really a governmental agency, but you must file a notice of claim with them within the 90 days, and you have to wait 6 months to sue. So you got to file it within 90 days. You got to wait 6 months to sue, but you must file the suit within the first year. If you don't, it's challenging sometimes because you don't know that, you often see cases get dismissed because they've either filed it after the 1 year deadline, or they gave the 90-day notice and they did nothing until 2 years closer to the normal statute of limitations, and that's not valid. Or they didn't file a notice of tort claim at all and then just filed a lawsuit. Or they filed a notice of tort claim and filed a lawsuit within 2 months later, or less than the 6 months. So it gets very complicated. So that's why you need an attorney really to guide you along this maze of statute of limitation issues.
Yeah, I think we talked about this before about like how difficult this could be when you don't have an attorney on your side, and I mean I feel like that goes with a lot of different situations, but man, that 90 days and the tort and all this stuff. I mean, this is like there's some crazy deadlines in there that who no one would ever know that in most of the time.
And most of the time, no. And of course, there's another one that I forgot to mention. If you're a minor in New Jersey, you have the ability to toll the statute or pause the statute of limitations until the minor reaches the age of 18. Once the age of majority is reached, then the statute of limitations starts to run. So
Okay.
you technically have until 20 if you're a minor to sue.
Since we're talking about timelines, when it comes to resolving a claim, what determines whether a case can be settled out of court, which I imagine is quicker, versus needing to file a lawsuit, which I would imagine takes longer?
Well, the reality of it is most cases will settle before trial. Having said that, we always try to settle cases once our client has finished all medical treatment. We obviously get all the records. We put together a nice demand package that basically includes all of the injuries, all of the treatments, all of the invasive treatments that have been done, any diagnostic testing, and we put all that together to the insurance company. Now, more often than not, unfortunately, the insurance company will lowball you. They'll give you a very low offer because if you're not really into the habit of litigating matters or trying cases, they will know that. I'm sure every insurance company has a file on every lawyer that practices personal injury law.
I'm sure.
Know which ones want to go to trial or which ones are not afraid to go to trial, which ones do not go to trial. So they'll make their offer with that in mind. And if you have an attorney who does not like to go to trial, and I have to say, trial work is a different beast altogether. You really have to be long-winded because trials take time. Not only do they take time, they take a lot of money. They take a lot of energy from the trial attorney himself or herself. They take a lot of expenses in terms of, the doctors that you have to bring into court to testify. It just becomes something that not all lawyers enjoy doing. Let's put it that way.
Mm-hmm.
So you have to make sure that the attorney is willing, if necessary, to go to trial. Having said that, just because a case is filed in court doesn't mean it doesn't settle. Again, more often than not, it will settle, whether it settles during discovery, whether it settles after depositions, whether it settles after arbitration. In New Jersey, there's something called non-binding arbitration for personal injury accidents. Once we're done with all discovery, the court will set up the case to go before a non-binding arbitrator, who's usually a person who is well-versed in personal injury law. And the arbitrator will, get a statement from both sides, a written statement, arbitration statement with some evidence and expert reports and things of that nature. And then the arbitrator will make a determination as to what the case is worth. And then either side has 30 days to either accept or decline and ask for a trial. So a lot of times cases will settle around the time of arbitration or shortly thereafter. But if they don't settle, then, you go to trial. That's the reality of it.
Yeah, absolutely.
The stronger the case in terms of liability and damages, the more likely it is to settle. The strength of the plaintiff will also be a determining factor in whether the case settles or not. So when we have depositions, a reason for the depositions obviously is to get the facts. But the other reason for depositions, in my opinion, is to see the type of witness that the plaintiff and or defendant will be on at trial should the matter go to trial. So if the plaintiff doesn't come off as a credible, reliable witness or gets flustered very easily or just isn't credible, there's less likely the insurance company will be afraid of that person at trial. And the same thing for the defendant. The defendant gets on the stand and gets in the deposition stand and doesn't do too well. It's also going to be reflected to the insurance company that's representing that defendant. So a lot of things go into factoring whether to settle a case or whether to try a case. Ultimately, though, the matter gets resolved based upon what the value of the case is worth. And every case is different. You can have the same injuries, but with two different people, and they have different results from the treatments. They have different prognosis going forward. So the value of those cases will also be determined based upon, how the plaintiff is affected in the long run by the injury sustained.
Now, I think people hear the phrase "no fee unless you win," and I think for a lot of times that could sound like marketing, or maybe not truthful, or maybe they just don't understand it. What does "no fee unless you win" actually mean in a contingency fee case like yours?
Well, the term contingency means it's reliant on an outcome of some sort. So when lawyers say no fee unless we win, their fee is contingent upon a successful outcome for the client.
Right.
So that could be a successful outcome in trial. It could be a successful outcome during settlement negotiations, and something gets settled before trial. So the lawyer in New Jersey, there's a sliding scale in terms of fees. So for the first $750,000 of recovery, the attorney collects 1/3. The next 750,000, it would be 30%, and then it slides down from there every 750,000. So if the attorney is not successful, the client does not owe the attorney a legal fee. Now, I have to make a distinction between what is legal fees and what are costs on the file. So as personal injury attorneys, we often have to expend money to obtain medical records, to obtain expert reports, to do investigative work through a private investigator. So all these are costs that the law firm may, at its desire, front, or it may require that the client pay for that upfront. This is something that isn't often, mentioned in, all the commercials, no fee unless we recover money for it. It's great. What about the costs? Are you responsible for the costs in the event that the attorney is not successful? That's something that every client needs to understand in terms with their attorney when they discuss the contingency fee. But the legal fee itself, if you don't win the lawyer's work, there's no payment for the work that was done, no matter how much time the attorney spent on it. Now, having said that, in New Jersey, you're not obligated to go with a contingency fee. You can decide as the client say to the lawyer, listen, I will pay you hourly. What is your hourly fee? Of course, there's no guarantee that you're going to be successful in your case. So you may end up paying hourly and not be successful. That's why in personal injury matters, contingency fees seem to be the way to go, to basically give reassurance to the client that, hey, the attorney is putting all this time and effort in and is going to do his best to make sure you get paid and you get compensation for the injuries that you've sustained.
Typically, what factors might drag a case out or perhaps speed it up a bit as a general rule?
Well, as a general rule, well, in New Jersey and in most states, obviously, you have to prove two things for a personal injury. You have to prove liability and you have to prove damages. So liability, the clearer the liability is in a case, the more likely there's not going to be an argument back and forth as to who's at fault.
Mm-hmm.
So that takes care of that. Usually the arguments are about damages. I believe the damages are worth, 100,000. Defense counsel believes the damages are worth 20,000. Insurance company believes the damages are worth 5,000, and you get the gist. So obviously, the stronger the damages, the stronger the ability to settle the case without all those back and forths.
New Jersey follows the comparative negligence rule. I think we've talked about this before, but just in case someone doesn't know, can you explain how that works and whether someone still can recover damage if they're partly at fault?
Yes. So New Jersey's comparative negligence system is very, very simple. In order for you to prevail against another person who was at fault in the accident or whom you believe is at fault in the accident, you cannot be more than 50% liable. So if you are, let's say, 50% liable and the other driver is 50% liable, technically you can go after them and your award will be reduced by 50%. But of course, if you're 50% and they're 50%, it's never a good idea to even think about that. However, let's assume for argument's sake that you're 10%, negligent. You're walking down the street on a block that you always walk in and you trip over a sidewalk hazard that's been there for a year and you, at this day, you missed it. Well, yes, they're at fault for obviously not taking care of the hazard, but you also have some comparative negligence, let's say 10%, because you've walked there before, you should have known that it was there paid attention. So in a situation like that, let's say it goes to trial and the jury awards 100,000, but holds the defendant 90% liable and you're 10% liable. The plaintiff would get 90,000 or 90% of that award because they attributed 10% to your negligence. So in a situation like that, that's the best way to explain comparative negligence. It reduces your compensation by the percentage of negligence attributable to you.
Okay, that makes sense. That's a great job of explaining it. Well done, Joe. All right, well, that's it for today's episode of Crash Course Injury Law with Joe Ghabour. To learn more about deadlines, settlements, and your rights after an accident, visit GhabourLaw.com. You'll find clear, practical resources on how New Jersey's injury laws work and what to expect if you pursue a claim. Thank you for listening. Don't forget to subscribe to our channel. We really appreciate it very much. Joe, it was great chatting with you as always. Thanks.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.